Tort is purely concept based. We'll try to go fast. I'll try to cover maximum topics. Okay, so that if there is some time, we'll try to. The only reason is we will speak something about contracts also. That is the only thing I wanted to make it fast. Okay, tort is a civil wrong. Tort is a civil wrong. So we'll come to that. There are different types of wrongs. So tort is purely civil wrong. It is not a contractual breach of contract or a criminal act. Okay, it is purely civil wrong. Civil wrong and not a physical thing. Physical thing is also included. Small physical element is also included in tort. We'll come to that later. So it is basically civil wrong where there is legal remedy for that. See, there should be a legal remedy also. Civil wrong and legal remedy lekapothe, it is not tort. So definition is a wrongful act other than breach of contract. So breach of contract is not tort. Okay, there is an agreement, there is a breach. It is not a tort because there are liquidated damages in the contract. Specifically, you will say if the contract is broken, you have to pay so much of money and kuda mana specify cheskuntamu. So for which the law provides a remedy. In breach of contract, there is a remedy. Tort is redressable by an action for unliquidated damages. So in that, so if the current has gone, so I think we can run for some time. I don't know how much battery it will last, my inverter, all those things. Anyhow, so are you able to hear?
Yes, sir.
Yeah.
Yes, sir.
I cannot. The problem is I cannot refer anything. I'll just give me 1 minute. I'll try to do something. Okay, for the power. Okay, small. I'll just 1 minute. Yeah, I'm there. So okay. So it is a tort is crooked. Okay, it is we call it crooked also. So it is a wrongful act other than breach of contract for which the law provides a remedy. Tort is redressable by an action for unliquidated damages. I told unliquidated damages is nothing but where there is no specific damage is determined. So it is for compensating the person wronged, not to punish him. It is not to punish him. So like that's what I told. Even Motor Vehicle Act and Consumer Protection Act are part of torts, but there is separate acts for them. So in those things, you get compensation. For Consumer Protection Act, they don't punish you. Even for Motor Vehicles Act, I mean, there is Criminal Act also, negligent driving, all those things. But in other cases, you had to pay compensation. Okay, so it is damage for your property or reputation. You can sue for compensation. See, there are two things: damage for your property or reputation. Any one of the things. So it is civil wrong, private injury against a person, not a public injury. Okay, public injury is Criminal Act, private injury. Infringement of rights. Okay, infringement of rights, it is legal rights violated without your consent. And there is a legal remedy. Okay, there should be a remedy. If there is no remedy, then it is not tort. It will not, because they cannot give you any damages. So damages available through civil courts. You cannot go to criminal court. So example, defamation, trespass, or negligence. So defamation is somebody shouting at you, defaming you. You can go to civil court. You can claim damages under torts. Trespass. Somebody is entering your property, so you are not losing anything, but you can penalize him for doing that. So they are coming it regularly, they are trespassing your property. So there is no specific 1 minute. రామకృష్ణ క్లాస్లో ఉన్నాను, మళ్ళీ చేస్తాను. యా చేయని, నేను తర్వాత చేస్తాను, ఒక్క నిమిషం సెషన్లో ఉన్నాను. రైట్. సో negligence, lot of times because of some negligent act, like accident is a negligent act, or you ignore something and because of that like you throw a cigarette butt and something is burnt, so due to that negligence somebody will incur some losses. So those things, such acts will come under torts. Okay, so UB just IBE remedium. So this, you remember these things, I'll share these slides. Okay, so UB just IBE remedium, where there is a right, there is a remedy. So where your right is affected, there is a remedy. So legal remedy, if there is legal remedy, then it will come under torts. Okay, so your right is there and it is affected and there should be a remedy. That is legal remedy. That is UB just IBE remedium. You what is that? They may ask you UB just IBE remedium. They will give you 3-4 options. Okay, where there is a right, there is a remedy. Remember this. UB just be remedium. Remedium, just remember that remedium. So remedy, there is a remedy. Okay, where there is a right, there is a remedy. Okay, wrongful act or omission. It can be an act or not acting also. Okay, not doing some work also is, that is omission. Legal damage, that is injuria. The injuria damage is also called injuria in Latin. So violation of legal right. So if someone blocks your way on your own land, you can sue even without physical loss. Okay, somebody blocks your way to your land, then you can sue. That is example. Okay, legal damage. So we'll come to that legal damages later. 1 or 2 case laws also, where people are not allowed you to vote, you can sue for that. Okay, they may give you compensation of 1 rupee, 10 rupees, whatever it is, but you can sue for that damage. Okay, so what is the difference basically? Okay, the crime and contract. Okay, tort is a private wrong. Breach of contract is also private wrong, but it is a violation of contractual duty and it is a liquidated damages are there. So it is covered under separate act. It is not part of tort. Okay, breach of, we are talking about contract also. That is the reason I'm specifically mentioning contract is a separate act is there and it is liquidated damages is there. So it is agreement. Everything will be there in the contract. We'll talk about that later. So where is tort, there is no agreement. There is no anything. So your right is affected. It is a private wrong. So you can have a compensation for that. So tort example is defamation. For crime, it is murder. Contract is non-payment for goods sold. If you sold some goods and they are not paying money, it is part of the contract. So I am trying to give you concept what is tort, making it more clear. Okay, examples of tort. Examples of tort is negligence. Okay, so somebody is not taking reasonable care, like he is not cleaning properly the floor he hasn't cleaned properly, and you fell down because the floor was not cleaned. You stepped there and you had a fall. So the negligence. Nuisance. So unreasonable interference with someone enjoyment of property, like it is that disturbing you in your property. Trespass, entry into others' land. Defamation, false statement harming reputation is affected. Okay, then assault and battery. Okay, there is small difference between assault and battery. Somebody can unmute and tell me if assault and battery.
Said without touching is assault, sir.
Okay. So they will ask this question, battery and assault also they will ask. So that is the reason I am asking you separately. Assault is only threat. Okay. So they may point out a gun at you. Okay, that is threat. So they may show you their fist that they like hitting you. They may not hit you actually. So they may, I see, even if they try to hit, it may miss. Okay, that is assault. More threat. Okay, whereas a battery, they will touch you. That is the only thing. Okay, slapping, hitting you, something like that. So that is battery. So force is used and it is intentional. See, unintentionally touching you is not battery. Intentional touching is battery. Okay. So it should be intentional. It should be force. They should touch you also. And there should be some injury. Injury can be, need not be physical injury. Okay. It can be your reputation injury also. If somebody is hitting you in public, okay, with hand, slipper, whatever it is. So your reputation is lost. So that is also injury. Not, I mean, serious injury like bleeding injuries need not be bleeding injury. So that is battery. Your reputation is impacted. Okay. Pushing somebody is also, they will push you back, right? It is part of battery. So this is a false imprisonment. So this is, yesterday there was, today morning, I think, today I saw in newspaper, Andhra Pradesh High Court awarded 10,000 rupees compensation for keeping one person for more than 24 hours without producing him in the court. Okay, not false imprisonment, but just something like that, because he was supposed to be presented before the court within 24 hours. He was brought more than 24 hours later. So there was, he was penalized. Police was asked to pay him 10,000 rupees. So if there is wrongful restraint also, court may penalize those things for such acts. So this is very important. In this case, you can see, 1 minute. So breach of duty. Okay. So it is causing damage due to negligence. Donoghue versus Stevenson, 1932. Okay. Here, another example is doctor leaving a surgical instrument inside a patient. Okay. So they may give you example also. Because of doctor negligence, he forgot to remove that cotton, some instrument, whatever it is part of negligence. They forgot to close the tap and there was heavy leakage and your apartment got, your clothes, everything got wet because of that, some neighbors act. So those things are also negligence. So negligence, you can sue for negligence also. So you are getting new actually ideas. See, negligence, all those things, people don't know how to sue. So you can sue it under torts. Okay. Law of torts. Nuisance. So somebody is creating nuisance like high loudspeakers and they will put shamianas, tents, everything in blocking the public road. Okay. So that is public nuisance. And if it is disturbing you only, it is private nuisance. So public nuisance, you can file a complaint. For private nuisance, where you are only you are disturbing, I mean, somebody putting, a neighbor putting high sound, you are affected. He is blocking your way to your flat by putting lot of things in the way. So such things is nuisance. Defamation is very important thing. Okay. Defamation is a false statement. So there are two things, libel and slander. So try to understand the difference. Libel is written or printed. It should be written or printed in the newspaper. Even TV channels comes under libel only. Okay. It is written or printed defamation. It is called libel. Slander is spoken defamation. Somebody is talking wrong about you is slander. So difference in the different defamation, it can be libel, it can be slander. So try to understand libel is written or a printed defamation. where somebody write wrong articles, false article against you. Slander is somebody talks about you about you wrongly. So what are the remedies? So damages, monetary remedy, injunction. So court may order to stop that wrong. I mean, somebody is obstructing your way. They may ask you to remove that. Okay. So restitution, somebody is taking your property or dumping something in your property. They will ask you to remove, restoring your property. That will be done. So these are the remedies. Damages, that is monetary damages, compensation is given. Injunction, where they will stop. Specific restitution, restoring your possession of your property. These three things are remedies. So what is the importance of torts? It protects individual rights, life, property, reputation, promotes responsible behavior so that people won't be responsible, provides civil remedies for wrongs. Okay, it is civil remedies only. Forms base for modern liability, consumer law, medical negligence, all those things. As I told, it is part of torts only. But see, you read Consumer Protection Act. We do that Consumer Protection Act. But we do that cases without understanding that it is part of torts. Okay, it is tort law only. Then this is okay. The tort law is not about revenge, it is restoring the balance. Okay. Criminal wrong versus civil wrong. Okay, just I have given that example. See, assault and battery, dual nature of wrong. You got it? It is assault and battery. I mean, somebody is hitting is a criminal wrong. And same time, it is civil wrong also. So, criminal offense under section so and so. For civil wrong, there is no specific section. It is part of torts. But you can claim damages under torts also for assault and battery. And you can file a criminal case also for the assault and battery. Specific these things. Okay. Only this particular thing where it is criminal wrong and civil wrong also. These are some important concepts. Okay, strict liability. Case law is also given here in this one. Raylands versus Fletcher, 1868. So this is very, very important case for strict liability. So next they have come to with absolute liability after this, but strict liability is a person who brings and keeps on his land anything likely to cause harm, or if it escapes, is liable for damage caused by its escape, even without negligence. So without negligence also, if it escapes, that is strict liability. See, without negligence also, if that thing is escaping from his property and causing damage to the neighbor's property, then it is part of strict liability. So here what happened? Raylands versus Fletcher. So Fletcher constructed some tank, okay, big water tank to store water for his agriculture land. Okay, but there were some underground mines, open, not open cast mines. It is underground mines were there in those days where some digging was done in neighbor's plot in the mines. So that water, because through ground it entered into the open tunnels of the mines of Raylands, and it caused flooding in that mines shafts. So here, even though it is not negligent, because he has taken enough care, but his water caused the flooding in the shafts of Raylands. So Raylands here filed the case and against Fletcher. So here owner is liable even though no negligence is there. It was held. So Fletcher has to pay compensation for the loss of Raylands. So here, yeah.
Sir, actually the matter is in court, civil suit is there. Somebody dump sand into your land. Then what is the situation, sir?
You can file a case. It is trespass.
Trespass. We can file police station.
Yes.
But first simple complaint we can give that did not take action, then FIR should be filed.
No need of complaint. How can you can file give a notice? No, see, it is a civil thing, right? So you give a notice to him that you remove the sand. Okay, you take there is a video recording evidence should be there. Of course, somebody should be there to do that. So if they are not taking, then you can file a case against him. So
But one more thing, sir. Because it is open land, we are not ready daily. We cannot observe, right? It is open land since somebody have dumped the sand and they went away. We don't know exactly who is dumped the sand and what is the scenario. MRO can file the case if sand is in our land. Then how? What is the
no.
situation?
So it is your duty to take care of your land.
Okay. First principle that one.
Yes. Okay.
But
So it is your duty. You should identify who has dumped it. You have to file a complaint before against him.
First we have to inquire who dumped it.
You have to have evidence also. Without evidence, you cannot file.
Acha. But evidence we cannot get it.
Yes,
Already.
no, let us say somebody has dumped, say, construction waste or digged material. So there is only one construction in that village. So it is easy for you, right? See,
that time, okay, sir. In this scenario,
if it is in city, it will be difficult. In rural areas, it will be much easier.
No, for that is fine, sir. In what you said, that is agreed. But in this case, we don't know who dumped it there. The sand.
You cannot file a
case.
You can file against a specific person only.
So first we have to find out who is the culprit.
Yes, against whom you will file.
Yeah, that is what. If we know also, we don't have an evidence. Then in that case, sir.
No, you cannot win. See, you should have evidence to win any case. He will say, I didn't dump it. So how can you prove it?
If somebody ready to give evidence orally also, it is okay, right?
Then yes, somebody, there should be some supporting evidence also. And that person says that it is, if he can see whoever's evidence is strong, they will win.
If we say it not belongs to me, then we can utilize that sand.
Yes, you can use that sand.
We can dump it somewhere.
Yes.
Thank you, sir. Clarification.
See, another, after strict liability, then recently, basically it has come recently, 30 years, 40 years onwards. See, Reliance case is 1868, more than 150 years old. Okay, this is 30 to 40 year old, less than 50 year old case is absolute liability. So absolute liability, it is strict than strict liability, much strict. Okay, so
yes.
So here exceptions are not given when it is basically against big businesses where they are using hazardous activities. Okay, it causes harm. The absolute liability is to compensate the victims, and no exception is allowed. Okay, there is no exception for this one. So it is, see, MC Mehta and Union of India, you will find lot of cases. MC Mehta versus Union of India, there will be 10 to 20 cases. MC Mehta is a environment fighter. He is an advocate also. He filed around 20-25 cases related to environment. So this is one of the absolute liabilities, one of the environmental cases. This is MC Mehta versus Union of India. See, there are three things it will be called. MC Mehta versus Union of India, oleum gas leak, Sriram Chemicals case also. Same case. Sriram Chemicals case. So company name is Sriram Chemicals. The gas which came out of the company is oleum gas. And the person who filed the case is MC Mehta.
So this one, the Bhopal gas is same one, no?
No. Bhopal gas is different. Oleum gas is Sriram Delhi.
Okay, sir.
Okay, that is another case. But this is oleum gas case. It is Delhi fertilizers company. Union Carbide. That is Union Carbide. Bhopal gas is Union Carbide.
Sir,
Sir. I forgot.
1984.
Okay. Yeah. So this is Sriram Chemicals, oleum gas, MC Mehta. Okay, all three are same. So there is no defense. Company must pay. They can say that we took every care. Company will, government or court will agree for everything, but they have to pay compensation to the victims. There is no escape in absolute liability. Even though there is negligence on somebody's part, whatever it is, sabotage is there, anything, but company is liable to pay. Clear? Absolute liability, strict liability.
Yes.
Okay. Strict liability, Rylands. Absolute liability, this is Sriram Chemicals or oleum gas or MC Mehta. Okay. then no fault liability. So compensation when no fault or negligence is proved. So because of your vehicle, some accident is caused, you have to pay some money. Okay, this is basically in accident cases. So that person has come in front of your car, but court sometimes may ask you to pay the compensation for the disability. Okay, no fault liability. This is no fault liability. This is very important, vicarious liability. So vicarious liability is you are paying for fault of somebody. Okay, you are paying for the fault of somebody. There are two slides for this one, vicarious liability. Okay, there is no, you are not causing any, say, let us say your driver is driving the vehicle, there is an accident. So you are liable to pay for that as the owner. Okay, so liability of one person for acts of another due to the legal relationship. That is master, servant or agent, principal, whatever this thing, master, servant. You are an employer, so you are liable for your employee's wrong. Principal, agent. So you principal is liable for Agents Act. You appoint an agent, so he acted some thing. So for his acts, you are liable. State liability. Even government is liable for his employees. If employees is doing, I will talk about that. If employee is doing government duty and that act is as per his regular duties, any loss caused because of the regular duties, state is liable to pay. Okay, that is state of Rajasthan versus Vidyavati. This is important case. State of Rajasthan versus Vidyavati, where government is liable for negligence of government employee. And another important, Kasturi Lal versus state of UP. Same thing, but there is no liability for sovereign functions. There are certain sovereign functions where government, that cannot be challenged in court. Sovereign powers. If something is intentionally removed, say your property is removed for by government, so by accident it is different. Intentionally by passing a legislation, then it is not part of tort. You can file for compensation under different act, but not under torts. Okay, government sovereign act cannot be challenged. Okay, so this is important. So here important thing is qui facit per liem facit per se. Okay, just read this one. So this is part of, so please don't use your phones. You are scribbling on the screen. Okay, qui facit per aliem facit per se. Part of vicarious liability. This is act of agent or is act of principal. That is qui facit per aliem facit per se. You remember this one? Okay, so it may be difficult, but you can recollect. Act of agent is act of principal. This meaning of this qui facit per aliem facit per se. They will ask such things. I don't know how it will be useful for us, but so they will ask such questions in torts, and you will not find it in barracks. You will not find anywhere. This is purely you have to learn qui facit per aliem facit per se. I'll share these slides also. There are certain another few couple of other things. You should learn them. Act of agent is act of principal. Responsible, principal is responsible for the actions of agents and servants. Okay, applicable to government servants like what we have seen in the previous slide. This is part of the vicarious liability. Okay, this qui facit per aliem facit per se is for vicarious liability. This is another concept. So very important, injuria sine damnum. Okay, injuria sine damnum. Legal injury without actual damage. Okay, there is no physical damage, but there is a legal injury. So they can file a case under torts. A person legal right is violated even if they haven't suffered actual loss. Injury without damages. Sine damnum, injury without damages. Okay, here person legal right is violated and they haven't incurred any loss because of that injury. There is very important thing, AIBE versus White. This is the case is there. Law that I have given this case also. AIBE versus White is the 1703 case. Okay. So it happened in Jammu and Kashmir. I don't remember the case. In India also it happened. Plaintiff was qualified voter, wrongfully prevented from voting, no financial loss, but court held the violation of a legal right is actionable. His legal right to vote is violated. So it is actionable. So AIBE versus White, remember case that is injuria sine damnum. So this will, what is the case? They will ask injuria sine damnum. They will give 4 cases. AIBE versus White is the case for that. Okay, where personal legal right is violated, but there was no actual loss. AIBE versus White, that is the case. Okay, damage without legal injury. Damnum sine injuria. Damage, damnum is damage. Sine, not, no. Injury. Damage and without injury. Here, injury without damages. There is an injury. Injury you have to treat under law. Injury is legal injury. Legal right violation. Don't misunderstand. Injury means physical injury. Legal right. In torts, it is legal right. Injury is legal right. Okay. Injury without damages. Damages without injury. Injuria, legal injury, basically. Damnum sine injuria. You don't go in depth, but damnum is injury, damages, harm or loss. Injuria is injury or legal right. If a person suffers a loss, but no legal right is violated, there is no tort. Even if actual damage occurs, so they might have, there is an actual damage. So even then, if there is no violation of legal right, law protects. So there is no compensation. Okay. So here example, A opens a shop next to B and takes B's customer. No, it is not a legal right, legal damage. B suffers financial. So it is, there is a very important case, Gloucester Grammar School case. Okay, Gloucester Grammar School case. And there is this case, I don't remember the other party name. Okay. So here Gloucester Grammar School, there was a school. This is 1410 case. Okay. So a teacher started a rival school. So few of the students from the school went and joined that rival school. So this Gloucester Grammar School owner, he incurred certain losses. So he filed a case. So since there is no legal injury, there may be loss to him because the school is open, but there is no violation of legal right. So no compensation is awarded. So Gloucester Grammar School case is very important. Remember this also. That is for damages without injury. Damnum sine injuria. Case, Gloucester School. Damage is there. Damage is physical this thing. Loss. Okay. But injury, no legal injury. Sign without legal injury. Injury, as I told, it is legal injury, legal rights. Injury, don't just remember that injury is legal right. Damnum is damages or loss. So there are certain defenses in torts. Volenti non-fit injuria. This is another concept they may ask. So if you are consenting voluntarily, you cannot complain. Like in boxing, you give a consent. If there is an injury, you cannot file a case. Volenti non-fit injuria. Voluntarily agreeing on something, you cannot complain. Okay. Volenti non-fit injuria. Then exturpi causa non ontur actio. I may not pronouncing, I don't know Latin, so I am pronouncing in my own way. Exturpi causa non ontur actio. Just remember this word. So plaintiff actually did wrong. So you are filing a complaint because you incurred certain loss, but the loss is because of your actions. Okay. So plaintiff must come to court with clean hands. This is valid for everywhere. Okay. Plaintiff must come to court with clean hands is the standard magnum. So exturpi causa non untur actio means plaintiff actually did wrong. So because he did wrong, he incurred some loss. So he cannot go and complain. So that is defense for tort. Inevitable accident. So there was no alternative. It was inevitable. So it occurred. So there is no compensation in that. Act of God. Okay. Natural disasters. Vis major, force major. Both are same. They may call vis major or force major. So force major is say beyond your control. Some things happen beyond your control. Like say you are a transporter. Somebody asks you to transport apples in your truck. So you are transporting apples. It should reach within 3 days. Otherwise, apples will be damaged. So you reach it there after 7 days. So apples got damaged. So they want to file a case. If there is no intentional or negligence, they can file a case. But vis major or force major clause is beyond your control. There was a national ban. It is beyond your control. Everywhere there was stopping, so you cannot come, you cannot travel. There was a petrol strike, so there was no petrol available or diesel available, you cannot transport. COVID is one example. Lot of people, force major clause is there because a lot of people couldn't perform their duties. So inevitable things happen. In those cases also, it is an exception, defense for tort. Then self-defense, if you do something in your self-defense, also you will not be compensated, you will not pay the damages. If because of necessity, you will not do that. Statutory authority, as I told, if the government is doing some acts as a sovereign authority, also it is you are protected. Okay, this is about torts. So I try to cover the maximum. So shall we do contracts? Bhim Singh versus State of Jammu and Kashmir, injurious sign, injury without damages. This is Jammu and Kashmir case also. So I remember Jammu and Kashmir. I don't remember the Bhim Singh name. Good. Thank you, Sushma. Okay. So shall we do contracts also?
Yes, sir.
Yes, sir.
Okay. So we are having very big crowd today. 56 people joined. Okay. So we'll try to finish contract fast because contract is you can carry Bayrak along with you. So just to make you understand, I'm taking this session. I thought of taking some other session, but the contract Muslim law takes more time. So we'll focus more time for Muslim law. Yeah,
Sir, family law, sir.
Yeah, family law. I'll take this session for family law. That mandatory. I'll do that. Then we'll do some at least 2 classes for the answering question papers. Okay, how to answer these 2 things. At least we'll have 3 or minimum 3, maximum 4 classes we'll have before the examinations. Okay. So we'll go for Contract Act. Able to see?
Yes, sir.
So yeah, I am not